I mean, she was
so perfect
she was
the way it's
with me
played.
throughout this whole process. So I think for better or worse, she was experienced the whole thing with me. So big beautiful summer movie, but it's
Yes.
actually like a pretty intimate movie. So we never thought, like, our eyeballs were not that big to think that we could put one of her songs in the movie, and it had to be. And there was a moment in the movie that just, it was missing this like emotional gravitas, and like, as soon as we put that song in, it was just like, I was like, that's the spot. I mean,
Hi, besties. It's Katie from Without a Crystal Ball. Let's get back into it. There was a bomb that was dropped yesterday. Baldoni's attorneys, Bryan Freedman, sent a letter to the judge, and he let the judge know that a subpoena that they had issued to a law firm that represents Taylor Swift was not overbroad and seeking irrelevant information. They were responding to a letter that Lively's attorneys had put to the court to notify them of the pending issue that was happening in the DC District Court. Venable had put forth a motion to quash and was basically saying this is overly broad, the timeframes don't make sense, we don't have any information to share. You could get this from them. We aren't a party to this. Just because we represent Taylor Swift doesn't mean we have information. And they were trying to say they didn't really know what they were seeking. And I don't know if they ever even met and conferred. And so immediately we saw the Blake team respond and file an intervention and say, listen, we're intervening in this motion, in this subpoena. You don't need these records. These records are irrelevant. It would be violating our privacy. It has nothing to do with this. And they're just doing this for improper purposes. All right. And once they did that, thus far, nothing has been put forth to a judge from Wayfair in the DC court. And that's because Bryan Freedman let the judge know in the court of New York Southern District, Judge Lehman, that he was in the process of meeting and conferring with the Venable attorneys about this subpoena. He told the judge this: the Wayfair parties anticipate that Venable's motion to quash will be mooted in short order as their counsel and Venable are conferring in good faith. However, the Lively party's insistence that the subpoena seeks irrelevant information is wrong. So their note to the judge was basically like, listen, we've gotten in touch with Venable. Right now we're meeting and talking about what it is that we're seeking, and we're trying to figure out what we're going to do about this information that we're looking for. And the information they're seeking is apparently related to possible witness tampering and evidence spoliation. Okay. And they're asserting that Lively requested Taylor Swift delete their text messages. They're also asserting that Michael Gottlieb of Wilkie Farr, counsel for their defendants, contact Venable attorney who represents Miss Swift and demanded that Miss Swift release a statement of support for Miss Lively, intimating that if Miss Swift refused to do so, her private text messages of a personal nature in her possession would be released. And the parties' counsel are further informed and believe that a representative of Miss Swift's addressed the inappropriate and apparently extortionate threats in at least one written communication transmitted to Mr. Gottlieb. And that's what they're looking for. And they said that, hey, we're going to work with them. And if we can figure out how to get this done, won't even have to worry about the subpoena. However, if these discussions are not fruitful, we'll either oppose the motion to quash or we'll withdraw the current subpoena in favor of something that's much more narrow and only seeking communications for that specific area about this potential witness tampering and the possible spoliation of evidence. So that obviously caused an uproar. I mean, what wouldn't? It's a huge storyline, right? It's a huge bit of information. But to be clear, Freedman is signing this to a judge in a sworn document, in a motion where his name is on it, and it's under the penalty of perjury. So he has no incentive to lie here, and he is doing discovery, which is a part of this process. And he was responding to a letter that they had filed saying that the information was irrelevant. Okay. Obviously, that ticked off Blake's attorneys. And now they are upset and they are seeking a motion to strike. And they're claiming that, first of all, this didn't even happen. They're lying. And you need to strike this from the record because it's laundering of defamatory statements. And I thought that part was just very cute because we all know who is being accused of laundering evidence, right? And something I've noticed about Blake's side is that they have put out a lot of allegations against Baldoni, right? And they have made a lot of allegations with no proof, right? And it's okay for them to do that, but if someone else does that, then it's defamation. So her attorney said that they were respectfully moving to strike the letter that's signed by Bryan Freedman filed earlier today. The letter was not filed with any evidentiary support of any kind, much less anything under oath. Falsely accuses Miss Lively and her counsel of engaging in witness tampering and evidence spoliation based on an undisclosed anonymous source. She requests the court strike the Friedman letter pursuant to its inherent power to control and to strike material from its docket that is abusive or otherwise improper under the circumstances. So, because this went public and he filed it in court, they want him to strike it from the record because they're calling it irrelevant and abusive. It should be unnecessary to respond to anonymously sourced, baseless allegations recklessly leveled without any supporting evidence. That's interesting. It is worth stating for the record, however, that each of the allegations in the Friedman letter is unequivocally and demonstrably false. As a legal matter, the Friedman letter is improper. It does not seek any form of relief, is irrelevant to any motion currently pending before the court, and serves no legitimate purpose. It is not useful to the court in any respect. Miss Lively filed a letter to which the Friedman purports to respond as a courtesy to inform the court about a motion to quash proceeding that Venable commenced in another federal court to preserve their own right to object to the third party subpoena. But she did not ask the court to take any action, and her letter did not merit or warrant any response from Mr. Freeman, let alone one that purports to manufacture a conspiracy theory in order to obtain communications from opposing counsel via a third party. Okay, anytime something is put into this case, their go to is to call everything a conspiracy theory. And they're refuting it completely and saying, listen, we didn't do this. It's totally false. And furthermore, everything that he put in there is irrelevant because he didn't even need to respond to the letter to the court. In the court, even if it's not a motion, and if a counsel puts in a letter to the judge and says, listen, judge, this is going on in a different district, this is what we're doing, the other side can absolutely reply to the letter to the judge if there's a discrepancy in the information that the counsel on one party is giving to this judge. And so the way I viewed his response was to clear the record as far as I'm telling you that this is what we're seeking because they've said it's irrelevant. So it's almost like they went to the court, made their statement, and then it just expected there to be no response. I don't believe on that basis that what he did was wrong, but obviously it's something that they don't want known or it's something that they find adverse to them and it's suggesting crimes basically and it's putting her attorneys at the center of some sort of criminal conspiracy to tamper with a witness. And of course, they're not going to like that. And I told you yesterday, that's a serious allegation to make. The apparent intent of the Friedman letter is to launder scandalous and defamatory allegations about Ms. Lively and opposing counsel into the press by abusing the court's docket and avoiding the order requiring attorneys in this case to comply with Rule 3.6 of the New York Rules of Professional Conduct. Within minutes of Friedman's letter appearing on the court docket at 1:50, media outlets began publishing stories concerning the Friedman letter, including one that was posted 40-plus paragraph article at 1:55 that asserted as fact that Miss Lively threatened to expose Taylor Swift's private texts unless she publicly sided with her in Justin Baldoni's feud. And then they link this to an article by Ruth Stiles of the Daily Mail. So the implication here is that Bryan Freedman tipped Ruth Stiles off, and somehow Ruth Stiles wasn't watching the docket, and she somehow drafted a 40-page article within 5 minutes. And so she must have gotten this from him. That sounds a lot what Wayfair has accused them of doing with the New York Times. We'll take a look at that article to see what it actually says in a minute. But that asserted as fact that Miss Lively threatened to expose Taylor Swift's private texts unless she publicly sided with her and Justin's feud. During a hearing on February 3rd, this court explained to the parties that it would intervene if it turns out that this ends up being litigated in the press in a way that would prejudice the opportunity of the parties to a fair trial. The court should promptly strike the Friedman letter from the docket to avoid exactly the result it presaged at the initial hearing. So, what they're telling the judge is this information is very damning to our clients, and it could absolutely impact Blake's ability to have a fair trial. I think the bigger implication here, I mean, yes, if it's not true, sure. But if it's true, it does make it hard for her to have a fair trial because the case could get thrown out. She could get sanctions. There could be criminal charges. There could be evidence that's tossed. In some extreme cases, if there is spoliation and witness intimidation on a civil end, there can be adverse directions to the jury that lets them know, like, listen, this person did this and she was found that she did this and this evidence was deleted. And anytime evidence is deleted, it's under the assumption that you would not delete evidence if it was not adverse to the party that they're deleting, that who's deleting it. So that could be something that happens as well. There could be criminal charges, there could be contempt of court, there could be fines, sanctions, attorneys' fees awarded. So Friedman's letter is already sort of implicating that if this is true, they could go for all of that against them. And so obviously their position is that it's false and we're going to go for sanctions against them. And it says whether or grant a motion to strike is vested in the trial court's sound discretion. Courts have the inherent power to control their docket and strike material that is abusive or otherwise improper under the circumstances. And it says this authority derives from a court's authority to manage its own affairs, so to achieve the orderly, expeditious dispositions of cases. Miss Lively respectfully requests that the court exercise its inherent authority to control its own docket and strike the Friedman letter as unnecessary, improper, and abusive. She reserves the right to move forward with sanctions consistent with the Rule 11 of the Federal Rules of Civil Procedure in connection with the Friedman letter at an appropriate time. You know how they say that if you bring attention to something, there's like the Streisand effect, and so it makes the situation even bigger. And that's kind of what's happening here because the motion to strike is going to give Wayfair an opportunity to respond. And my goodness, did Mr. Friedman respond in a big way. Some of the claims they made there were that nothing was under oath, it was all through anonymous sources, and nothing can be trusted here, and it's only being done for abusive reasons. Well, he satisfied a couple of their concerns, and here's what he told the judge. We write in response to a letter, motion to strike filed by the plaintiff and consolidated defendant Blake Lively. The motion asks the court to strike my letter of May 14th, 2025. The May 14th letter was submitted in response to Miss Lively and consolidated defendant Ryan Reynolds' corrected letter of May 13th. The May 13th letter purporting to inform the court of their request to intervene in an action pending before a different federal court relating to a motion of Venable LLP to quash the subpoena served on them by my office. The premise of the motion is that I made a deliberate and shameless misrepresentation to the court, and the facts set forth in the May 14th letter are false and unfounded. That is not so. Attached to this is an exhibit executed under penalty of perjury stating the factual basis for the statement set forth in my May 14th letter. Ooh, so he's upping the ante. He's going to go on record, and this is if he's lying, he can get charged with perjury, okay? So, notably, the motion is signed not by Michael Gottlieb, whose conduct gave rise to my office issuance of a subpoena to Venable, but instead by another attorney from a different firm representing the Lively defendants. The motion also faults the May 14th letter for being filed without evidentiary support of any kind, much less anything under oath. This opposition supplies the sworn affidavit that Lively argues the May 14th letter lacked. Finally, and most notably, the motion claims that the facts set forth in the May 14th letter are unequivocally and demonstrably false, yet it is unsupported by any sworn declaration to that effect, much less from Michael Gottlieb. That's interesting. The letter was signed by Ezra Hudson, not by Michael. So Michael didn't go on under oath. Michael didn't swear under the penalty of perjury. Maybe he will now, but it definitely was signed by Ezra and filed by Ezra Hudson, a completely separate law firm. The motion further contends that the May 14th letter was improper because it does not seek legitimate purpose. Of course, the same could be said of the Lively defendant's May 13th letter, which Miss Lively claims to have submitted as a courtesy and in which she did not ask the court to take any action. In the May 13th letter, the Lively defendants claim that the subpoena served on Venable seeks the Lively defendant's attorney communications, including those of Mr. Gottlieb, with no explanation as to how they could be relevant to any party's claims or defenses in this litigation. Given that Miss Lively herself admits that in the May 13th letter, she did not ask the court to take any action, nor could she, given the motion to quash the subpoena to Venable is pending before a separate court and is outside the court's jurisdiction, it is apparent the May 13th letter was filed with the court for the purpose of besmirching the Wayfair parties and their counsel. A response was necessary. The May 13 letter claims in open court that my office issued the subpoena to Venable for an improper purpose rather than in pursuit of relevant documents. Accordingly, we submitted the May 14th letter to correct the record. The motion should be denied. So that's interesting. He is pointing out that she didn't really need to send the letter to let them know about the motion to quash issue that's going on in another district, in another court where the judge has no jurisdiction. And he's alleging that the only reason she did that was to make it look like his attorneys were involved in improper abusive conduct and issuing subpoenas without cause, which is abuse of the discovery process. So she was already shooting shots at them and making accusations at them alleging misconduct. And so he's saying, I had to respond to that because that's not what we were doing. So then he ups the ante, you guys, and this is where it gets a little bit wild. He tells the court in a sworn affidavit the following. He lets them know where he's a partner of and all of that. So he submits this in opposition to the motion to strike filed on May 14th by Blake Lively regarding my May 14th letter, elaborating on the basis for the Wayfair party's subpoena to Venable LLP. So be careful what you wish for, I guess, is what I'm going to start this out with. But on February 14th, I received a voicemail from a person very closely linked to Taylor Swift, whom I subsequently called back the same day. Out of respect for the individual in question, I am not identifying them at this time. However, should the court direct me to do so, I will comply with the court's order. So he's protecting this witness who's close to Taylor. So a confidant of Taylor's came forward, is what he's saying, and very closely linked. Could it be Travis Kelce? Could it be Tree Payne? Could it be one of her managers? I don't know. But during the February 14th phone call, which lasted approximately 1 hour, the speaker told me that they had been informed that Douglas Baldridge, counsel for Taylor Swift and a partner at Venable LLP, had received a phone call from Michael Gottlieb, counsel for Blake Lively and Ryan Reynolds, during which Mr. Gottlieb requested on Miss Lively's behalf that Taylor Swift make a social media statement in support of Miss Lively, given her absence from the Super Bowl that year, and stated that if Miss Swift failed to do so, Miss Lively would release 10 years of private texts with Miss Swift. The individual also told me that they had been informed that Mr. Baldridge had accused Mr. Gottlieb of extortion and ended the call. During the same February 14th call, the individual told me that they had been informed that 4 or 5 months earlier, Miss Lively had requested that Miss Swift delete her text messages with Miss Lively. I was connected to this individual through a mutual friend who informed me the individual wanted to talk. We have had several phone calls since February 14th. On a later call with the same individual, the individual told me that Mr. Baldridge had sent a written communication to Mr. Gottlieb relating to the phone conversation. My office issued a subpoena to Venable LLP for the purpose of seeking the aforementioned written communications. I declare under the penalty of perjury pursuant to 28 USC 1746. Okay, so it's February 14th, and they're demanding she put out a statement because Taylor was at the Super Bowl, but Blake didn't go. And Blake's camp was publicly saying that she skipped it because of the controversy with the case. And Taylor's side was saying publicly that she wasn't invited and that Taylor was distancing herself from Blake due to feeling used by being called a dragon and feeling exploited. And so, if Taylor's public statements and her leaks are saying Taylor didn't invite her because Blake is using her as a weapon in this lawsuit, Lively demanding that she go onto social media to be supportive of Lively would be obvious that Swift is going to take her side in the legal case, trying to then get the public perception that there's a rift between the two of them over this lawsuit effectively quashed in the media. So, if that's true, that's pretty damning. And if they called it extortion in real time, that's also pretty damning. And it's akin to what happened with Justin Baldoni, right? When he was told to put out this message or else the gloves would come off and I will expose you. Now, to be fair, 10 years of text messages haven't been released, right? But they could be via this lawsuit. And that could 100% humiliate Taylor. But if her attorneys intervened immediately and said something and basically threatened back with, like, we'll sue you if you do that, it could have made her stop. So the person that's telling her this is someone very close to Taylor. And it's right after the Super Bowl. Maybe it's Travis, maybe it's someone from the team, but I have to assume here that Taylor isn't going to tell very many people about what's happening with her lawyers. Okay. Because whoever she's telling this to, it's waiving attorney client privilege. Okay. So, and they're not married. So that would be, so spousal privilege isn't available. But whoever she's telling this to, she is close enough to that she trusts them. And if that person then is going to Freedman, the question here could be that Taylor wanted this person to come forward for her to Freedman to let them know what was happening so that Taylor wouldn't have to say anything publicly and she didn't have to intervene in it, but she could have someone close to her intervene on her behalf, if that makes sense. And then that same person also is told that Swift told them, obviously, that she had requested Swift delete the text messages with Lively. So the person reaches out to them. They're linked up through a mutual friend, and he is willing to share who the source is if the court directs him to share. So he's basically telling the court they're not anonymous. They are a very real person. They have very intimate details that they know about Taylor's legal issues that are not public regarding this case. And if you tell me to say their name, I will, but I'm protecting them right now because of the discovery and because of all of the intimidation these people are receiving anyway, right? So the same person is the one that's telling them these things, and they're very closely connected to Taylor Swift. So it's someone in Taylor's camp. You can do with it what you want with that. But I would venture to say that this is what happened because he's under the penalty of perjury. He's making these statements under the penalty of perjury. He is not saying that the information is true. He is saying, this is what the person told me. And I'm telling you that this is what I was told by this person. And God, it sounds so much like you better come out and support me and defend me. and get this bad press off of me. You guys, I'm sorry, but if you fuck with Taylor Swift, who has way more followers, is a bona fide superstar, and is in a stratosphere in her fame that exceeds Ryan Reynolds times a billion, you have fucked with the wrong one. And Taylor is going to protect herself. She's going to protect her friends. She's going to protect her business, and she's going to protect her image before she ever bends or bows to that kind of behavior. And if this is true, it would explain why she has said nothing publicly, because it's been going on since before the lawsuit happened. It would also explain why Taylor had been distancing herself. And they said that 4 or 5 months before this happened, that Lively requested that she delete her text messages with Lively, that Swift do that. So 4 or 5 months is October. October was the last time Taylor Swift saw Blake Lively. And who was she with? Travis Kelce. They went out for dinner. Ryan and Blake went for dinner with Travis and Taylor, and that's the last time they've been seen publicly together. So maybe it's Travis. But whoever this person is has the kind of information you would only tell someone that you really trusted, like your boyfriend or your mom or your manager or your publicist. So, what are your thoughts about this response? Do you believe Brian now that he's gone on record? And how do you think Blake's team is going to respond? I mean, he has a sworn document with a notary here saying that this is under the penalty of perjury. That's how serious he is here. And Gottlieb hasn't done that. So you tell me what you think. Who do you believe? And do you think that whoever came forward for Taylor is there to protect her and or are they lying? Because to me, if this was Travis doing this, this is a boyfriend that's out to protect his girl, and that's a good man if it's Travis. That's what I'm saying. So what are your thoughts? Let me know in the comments below. Let me know what your thoughts are about the whole thing. And please make sure to give this video a thumbs up. Make sure to share this video with your friends and click the bell so you never miss a video. Thanks so much for watching. Bye, besties.